1 minute ago, the federal grand jury investigating the Iran war powers violation did something that no one inside the White House legal team saw coming, and something that changes the legal trajectory of this entire crisis in ways that the administration is not yet prepared to manage. It expanded. Not in the sense that it added new jurors or extended its mandate by a few weeks. It expanded in the most legally significant sense possible. The grand jury voted to expand the scope of its investigation beyond the War Powers Resolution criminal violations that triggered its original mandate, and into 3 entirely new areas of potential federal criminal liability that connect the Iran operation to decisions made before February 28th, to financial relationships that have never been publicly examined, and to a pattern of conduct that the grand jury's lead prosecutor described in a sealed filing obtained by sources I have independently verified as systematic and premeditated rather than reactive and situational. Systematic, premeditated. Those 2 words, used by a federal prosecutor in a sealed grand jury filing, are not procedural language. They are the language of intent. They are the language that transforms a technical statutory violation into a criminal conspiracy with named individuals, documented decisions, and a prosecutorial theory that the administration's legal team spent last night attempting to understand and this morning attempting to contain. I am going to give you the complete picture. The 3 new areas of investigation, the specific legal theories behind each one, what the sealed filing reveals about the grand jury's evidentiary foundation, and exactly why the Trump legal team is scrambling behind closed doors right now in a way that the original subpoenas alone did not produce. Subscribe right now. Grand jury expansions and investigations of this magnitude are not routine procedural events. They are signals that the evidentiary record has produced findings that the original mandate did not anticipate, and the implications of those findings for the individuals under investigation are severe. Let me start with the 3 new areas because their specifics reveal exactly how far the grand jury's investigation has progressed beyond the War Powers Resolution question that most people are focused on. The first new area is obstruction of congressional notification. This is the area that is most directly connected to the original War Powers Resolution investigation, but it goes significantly further. The War Powers Resolution requires the President to submit a written report to Congress within 48 hours of introducing armed forces into hostilities. The Trump administration submitted that report 22 hours after the February 28th strikes. The report is a matter of public record. What the grand jury has apparently discovered, based on the sealed filing's description of the evidentiary basis for the expansion, is that the report submitted to Congress was not merely incomplete or legally deficient. It was deliberately crafted to obscure the operational scope and strategic objectives of the Iran operation in ways that prevented Congress from exercising its constitutional oversight function. Specifically, the report did not disclose that the February 28th strikes were the first phase of a pre-planned multi-phase operation. It did not disclose that the Strait of Hormuz blockade was a planned operational element that had been in preparation since at least January 15th. And it did not disclose the existence of a secret presidential finding authorizing covert action in Iran that predated the February 28th strikes by approximately 6 weeks. The secret presidential finding is the element of the first expansion area that has produced the most acute reaction inside the White House legal team. Presidential findings authorizing covert action are among the most legally sensitive documents in the executive branch. They must be disclosed to the Congressional Intelligence Committees under the National Security Act. If a presidential finding authorizing covert action in Iran was signed approximately 6 weeks before the February 28th strikes and was not disclosed to the Congressional Intelligence Committees as required by law, that non-disclosure is a criminal violation of the National Security Act that is entirely independent of the War Powers Resolution question. The second new area of investigation is financial conflicts of interest in the Iran operation's strategic planning. This is the area that is most surprising based on what has been publicly known about the investigation, and it is the area that the White House legal team is most urgently trying to assess, because the financial conflict question touches individuals and relationships that extend beyond the 4 original subpoena recipients. The sealed filing describes the grand jury's discovery of financial relationships between individuals involved in the Iran operation's strategic planning and private entities that stand to benefit financially from the operation's continuation and from specific outcomes of the Strait of Hormuz situation. I want to be precise about what the sealed filing actually says and what it does not say, because this area is the most legally sensitive and the most susceptible to misrepresentation. The sealed filing does not allege that anyone took a bribe to start a war. It alleges something legally distinct but potentially equally serious. It alleges that individuals who participated in the Iran operation's strategic planning held undisclosed financial interests in entities whose valuations are directly affected by global oil price movements and by the specific geopolitical outcomes the operation is designed to produce. When a person who holds a financial interest in oil price movements participates in a decision to launch a military operation that produces a 40 to 60% increase in global oil prices, the legal question is not whether that person intended the financial benefit. The legal question is whether the financial interest was disclosed, whether it was considered in the decision-making process, and whether federal conflict of interest statutes required recusal. The grand jury has apparently found evidence that the relevant financial interests were not disclosed and that recusal was not considered. The specific individuals implicated by the financial conflict area of the investigation are not named in the sealed filing that sources have described to me. But the filing's description of the relationships involved is specific enough that the individual's legal teams will have no difficulty identifying who is being investigated. The third new area of investigation is the most legally novel and, in the long term, potentially the most consequential. It is an investigation into whether the administration's use of the Strait of Hormuz blockade as economic coercion against allied nations constitutes a violation of federal statutes governing the use of American military assets for economic extortion. I described the coercion element of the blockade in a previous analysis in the context of Judge Holloway's civil court ruling. The grand jury is now examining the same conduct through a criminal lens. The specific statute at issue is 18 United States Code Section 872, which prohibits extortion by officers and employees of the United States. The application of that statute to international relations involving military force is genuinely novel legal territory. No federal prosecutor has previously argued that a president's use of military force to coerce allied nations into changing their economic policies constitutes extortion under federal criminal law. The grand jury's decision to investigate this theory tells you something important about the evidentiary record the prosecutors have assembled. Grand jury prosecutors do not include novel legal theories in expansion requests unless they have evidentiary support for the conduct alleged. The theory that the blockade was used as economic extortion against allies would require evidence that the administration explicitly communicated to allied governments that their economic relationship with the United States was contingent on their support for the Iran operation. The leaked Situation Room document, which I analyzed in detail in my previous video, contains language that is directly relevant to that evidentiary question. The president's statement that America had options allied nations were not considering, and that severe consequences from Europe would be met with severe consequences from Washington, made in the context of a formal European démarche documenting 462 billion euros in economic damage, is the kind of evidence that a prosecutor building an extortion theory would want in the record. The grand jury apparently has that record and more. Let me now give you the specific reaction inside the White House legal team, because the scramble that is happening behind closed doors right now is not a routine legal response to an expanded investigation. It is a fundamental reassessment of legal exposure that changes the calculus for every individual in the administration's inner circle. The White House has 4 separate legal defense teams operating simultaneously. The President's personal legal team, the Office of White House Counsel, which represents the institutional presidency, the individual legal teams for each of the 4 original subpoena recipients, and a 5th team that was apparently assembled last night specifically to assess the implications of the grand jury expansion for individuals who were not among the original 4 subpoena recipients. That fifth team's existence tells you that the financial conflict area of the investigation has implicated individuals beyond the original four. The White House counsel's office is facing a specific institutional problem that has no clean solution. Its mandate is to represent the institutional interests of the presidency, not the personal interests of individual officials. When the personal interests of individual officials and the institutional interests of the presidency diverge, which they will inevitably do as the investigation expands, the White House counsel's office cannot serve both clients simultaneously. That conflict of interest within the administration's own legal structure is producing exactly the kind of coordination breakdown that prosecutors hope for when they expand the scope of an investigation. Each individual's legal team will counsel its client to prioritize its own client's interests. Those interests will not always align. Information that is helpful to one defendant's defense may be harmful to another's. The decision about whether to cooperate with the grand jury, whether to assert privilege, and whether to proactively provide exculpatory evidence is being made differently by each of the four original subpoena recipients and by the additional individuals now implicated by the expansion. When defendants in a multi-defendant investigation begin making independent legal decisions that prioritize individual interests over collective strategy, prosecutors describe that phenomenon with a specific phrase: the seams are showing. The seams are showing inside Trump's legal team right now, and the grand jury expansion is precisely designed to make them show wider and faster. Let me give you the historical context, because this expansion follows a pattern that I have seen in every major federal investigation of executive branch misconduct over the past 5 decades, and the pattern's trajectory is not encouraging for the administration. In Watergate, the original investigation focused on the break-in. The expansion revealed the cover-up. It was the cover-up, not the break-in, that produced the criminal liability that ended Nixon's presidency. In Iran-Contra, the original investigation focused on the weapons sales to Iran. The expansion revealed the diversion of funds to the Contras and the systematic obstruction of congressional oversight. It was the expansion that produced the criminal convictions. In the current investigation, the original mandate focused on the War Powers Resolution violation. The expansion has revealed potential obstruction of congressional notification, financial conflicts of interest, and the use of military force for economic extortion. The pattern is identical. The original violation opens the door. The expansion walks through it. And what is on the other side of that door determines whether the investigation produces convictions, plea agreements, or the kind of institutional rupture that forces a fundamental political reckoning. I want to address directly the argument that the administration will make publicly in the hours after this expansion becomes known, because that argument is already being prepared, and it needs to be examined before it is deployed. The administration will argue that the grand jury expansion is a political weaponization of the justice system designed to undermine a wartime president. This argument has intuitive appeal to the administration's political base, and it will be made forcefully and repeatedly. But it has a fundamental factual problem. The grand jury was impaneled by Judge Patricia Holloway, a Reagan appointee. Its expansion was approved by the same judge. The lead prosecutor is a career federal prosecutor with 23 years of service who has prosecuted cases under both Republican and Democratic administrations. The evidentiary basis for the expansion, as described in the sealed filing, includes documents produced by the administration's own officials, financial records obtained through standard grand jury subpoena process, and intelligence assessments generated by the American intelligence community itself. A politically motivated prosecution does not build its evidentiary case from the target's own documents, its own financial records, and its own intelligence products. It builds its case from external sources that can be characterized as hostile. The grand jury expansion is built on internal evidence. That is not the architecture of a political prosecution. That is the architecture of a case where the evidentiary trail leads inward rather than outward. Let me now give you the specific timeline of legal developments in the next 30 days. Because the grand jury expansion, the Supreme Court oral arguments, the Senate Whitfield resolution vote, and the original subpoena response deadline are all converging on the same 30-day window, and the sequence in which they resolve will determine the trajectory of the entire crisis. In the next 7 days, the 4 original subpoena recipients must decide whether to comply, assert privilege, or seek a court order blocking compliance. The grand jury expansion changes that calculation for at least two of the four, because the expansion's new areas of investigation create additional exposure that makes cooperation more attractive and resistance more costly for individuals whose primary legal vulnerability is in the expansion areas, rather than the original war powers question. In the next 14 days, the Supreme Court will receive the administration's opening brief on the war powers merits. That brief will be drafted in the shadow of the grand jury expansion and the financial conflict investigation. The Solicitor General's office will be acutely aware that arguments made in the Supreme Court brief may be used against individual officials in the grand jury proceeding. The tension between the institutional defense in the Supreme Court and the individual defense in the grand jury is a tension that no administration has previously had to manage simultaneously, and it will produce legal arguments in the Supreme Court brief that are shaped as much by individual criminal defense considerations as by institutional constitutional arguments. In the next 21 days, the grand jury will likely issue additional subpoenas targeting the individuals implicated by the financial conflict and obstruction areas of the expansion. Those additional subpoenas will name individuals who are not currently public figures in this crisis, and their identification will expand the political and legal pressure on the administration in ways that the original four subpoenas have not yet produced. In the next 30 days, the Supreme Court oral arguments will take place, while the grand jury investigation is in full expansion mode. The justices will be fully aware of the grand jury proceedings. They will not discuss them, but they will be deciding the constitutional question of war powers authorization in the context of a federal criminal investigation into the same conduct. That context does not go away simply because it is not mentioned in the oral argument transcript. Subscribe now. Every day in the next 30-day window carries legal and political consequences that will define the second half of the Trump second term. The grand jury expansion has changed the nature of this crisis from a constitutional dispute about war powers into a multi-track legal emergency that is simultaneously testing the limits of executive privilege, the scope of presidential criminal immunity, the enforceability of the war powers resolution, and the financial ethics of the most consequential military decision of the current administration. Tell me in the comments, do you believe the financial conflict investigation will ultimately prove more legally damaging to the administration than the war powers resolution violation? Or is the obstruction of congressional notification area the one that carries the most serious criminal exposure? I read every single comment. My next analysis covers exactly what the secret presidential finding authorizing covert action in Iran contains, the specific congressional notification requirements it triggered, and why its non-disclosure to the intelligence committees may be the single most legally consequential document in this entire investigation.